topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show where the man is right. For the last 17 years, we have brought you the finest experts in the field of legal, health, financial, and home improvement. Speaking of 17 years, for the last 16 years, Kay Bender-Rimbaum has been doing a show with us. In fact, when they started, there was no Tampa office, which we're doing today. There was no Orlando office. There was 2 offices. There are 4 offices now. This is our community association law show, one of our most popular shows. And this show here, which is the last Tuesday of each month at 5 o'clock Eastern time, this is becoming one of our top 5 shows. Good afternoon, Attorney Kirsten Enns.
Well, hello, Steve.
It's good to see you. I know you've got such a busy plate. I'm so glad you could join us. Last time, I think we missed it. I was sick last time, so it's been a couple months since we've seen you, but I got to tell you, I'm glad you're here. We have got all these new listeners. So could you tell them about Kay Bender-Rimbaum?
Yes, definitely. So first, for those of you who are just joining the show for the first time, listening for the first time, I'm Kirsten Hensa. I am a partner and managing attorney of the West Coast office for Kay Bender-Rimbaum. So for those who are not familiar with the firm, we are an exclusive community association law firm. So that means that we represent your condominium, HOA, and cooperative associations in the state of Florida. As Steve had mentioned, our main office and where we started is in Pompano Beach in South Florida, but we have since grown and expanded. And now we do have office locations in other parts of the state, including Palm Beach Gardens in the Orlando area. And then I'm on the West Coast in the Tampa area. I personally have been with the firm since 2010 and practicing going on 18 years. So it's been quite an adventure.
Well, I want to tell all of our new TikTok listeners, this show is our community association law firm. If you live in that condo, if you live in that HOA, you're always wondering about some of the rules, or you might be on the board and you've actually got questions. This is the greatest show to tune into. For the next 50 minutes, what we have is we have people who write in questions, and it makes my job so much easier. So on TikTok, if you've got a question about community association law, HOA, condo law, just write us down in the comment line. We'll try to get on. We've got so many people who've written questions in today. I don't know if we'll be able to get to them, but at least you get to listen to the show live on community association law. So, Kirsten, are you ready to get started?
Let's do it.
Okay. I've got to ask this because I'm always so curious. What is today? We're in July. God, we're almost done with July. What is like the biggest question that people call and ask?
Oh man. I think there's a host of issues, right, that every association faces, but I feel like of late I'm seeing a lot of issues involving owners who are abusing the records inspection procedures, or at least the board feels that they are abusing the process by making constant records requests. And so it's just, guiding the board in terms of, what the statute allows, what owners are entitled. So that's, I think, a big one. Complaints from board members of owners that they feel are harassing the board with constant complaints. So that's another and as of late, because of the SIRS and the milestone, I feel like we're very busy with a lot of contract review, right? So we assist boards in reviewing contracts, revising them, and then assisting with contract negotiations, right, and getting these projects done. And a lot of that sometimes involves, looking at budgets, looking at reserves, figuring out the funding. So that's been another area that we've been assisting with as of late.
Okay, well, let's start off with Ron in Tampa. We got so many letters from Tampa this month. So for an HOA, our board passed a special assessment for major clubhouse repairs. One of our owners believed that the governing documents require an owner vote. The board disagrees. What are the owner's options?
Well, I would say the first thing is the owner should really take a look at the governing documents and confirm that such, approval is in fact in the governing documents, right? I think you said the owner believes, well, it's either there is a restriction in the document or there isn't. And even if there is a restriction in the governing documents that requires some kind of membership approval for special assessment, there is case law. So this is not in the statute, but there is case law that's developed over time that addresses, necessary maintenance and repairs. And what this case law provides is that if the association has to do necessary maintenance repairs, right, and has to adopt a special assessment in connection with these repairs, then the association, the board can do so without membership approval, even if the governing documents have a provision requiring membership approval. And so I guess the $1 million question here is, is the special assessment being adopted in connection with necessary repairs? I think you said they are, but and I mean necessary as opposed to, let's say, adding a pickleball court, right, or something that's more cosmetic, more of a capital improvement, and not necessarily a repair issue. The owner can always consult with an attorney who practices in the state of Florida, and to help him or her figure this out.
Well, it's amazing. There's you probably would understand. We get so many pickleball questions, but I think we've even got a couple today. But let's go to Greg in Tampa. Removal rules for appointed no member vote as no quorum HOA board of director members who have not met educational 90-day time requirements. Can rest of the BOD replace immediately with volunteers who did take the course?
So if a board member has not complied with their board certification or continuing education requirements under both Chapter 720 and 718 of the Florida statute, the board member would be suspended from the board automatically, right? So there's no affirmative vote that is required for the board to suspend that director. And then the statute also allows the board to temporarily fill that vacant seat until that suspended director fulfills their obligation. So that's certainly an option that the board can exercise by temporarily filling that vacancy.
Kirsten, I got to share this with you. We had I guess there are a board member in St. Pete just wanted to write in to tell you how much they enjoy the way you answer questions and your knowledge, and that they are going to be they're going to be calling you to set up an appointment to come talk to their board. That's pretty good.
That's very nice. Appreciate that.
Yes.
And this goes, generally for, other attorneys in the firm itself. We try to respond to questions from board members or clients, in a way that you can understand, right? You don't need 20 pages of case law. You just want to know basically, how to address the issue. And so we strive to put things in terms that board members can understand. So I hope that, that's helpful to them.
And one of the things I want to add is Kay Bender, and I know this because we do shows like this all over the country, and Kay Bender really cares about education. You offer so many courses during the month, free courses. You do 3 shows a month with us. You're always educating people free, and it's that and customer service, I think, are some of the most important things at Kay Bender.
Yeah, I mean, that's, that goes without saying. I think a lot of attorneys in general forget that at the end of the day, we're still in the customer service, business, right? And, it's important to reach out. And I think we try to do that with, with our education. With all the webinars and in-person seminars, we try to also do more in-person seminars in the local areas, because that's really when you get, the one-on-one connection with the directors. And yeah, I mean, in terms of customer service, I'm always surprised when, a new board retains the firm. And the complaint that I often hear is that, we try to call our attorney and it's been a month and they haven't even, responded to our email. I don't understand, but that doesn't happen at KBR.
No, not at all. And I got to tell you, this is important to me. What I've learned over the years is that this is basically all Kay Bender Rimbaum does, is community association law. And I can't tell you how many firms out there that I call them, they put a shingle up, as the areas that they work in, and they'll put up their community association law, but they do bankruptcy, do criminal, they do PI. And I've learned over the years, when you just concentrate on one area like Kay Bender Rimbaum does, you get the best of the best.
Thanks, Steve.
So let's go on to Stephen in Tampa. If an association has $1 million in reserves for painting and consulting, comes up with a plan that costs them only $800,000, does the remaining $200,000 stay in reserves?
Yeah, so those funds that have been specifically allocated for the painting, will remain earmarked for painting. So if you've done painting now, right, and your paint is good for another 30 years, and you want to use those $200,000 that surplus in the reserve account for alternate purposes, perhaps you have other projects and have a shortfall, there is a statutory requirement to obtain membership approval before you can use reserves for alternate purposes, for purposes other than for which they were originally intended. And this only applies for non-SERS reserves. Okay, so for those condominiums that are required to do the SERS, the Structural Integrity Reserve Study, okay, just to be clear, the statute no longer allows boards to use SERS reserves for alternate purposes. Okay, so this would only apply for non-SERS reserves. Okay.
I just want to remind, we have to actually do TikTok different. We are talking about community association law. We're with the K. Bender Rimbaum law firm with offices throughout Florida. Just if you have a question, put it in the chat box, but please give us a like and follow us. Let's go to Karen in St. Petersburg. She wants to know if a current board of director member hits the 8-year term and a year and a half into the second year term, is he automatically off the board, or does he get to finish the term before being termed out?
So in our opinion, this director gets to finish the term. There's nothing in the statute that says that if your 8-term limit comes up, in the middle of the term, that you're automatically kicked out of the board. So, I think a reasonable interpretation of the statute as it's currently written is that the director can serve out the remaining portion of the term that he has left. Now, once his term expires, then he would not be able to to be a candidate to get on the ballot for the next term, unless of course he meets the statutory requirements. Now, having said that, I'm not aware that the division has taken any official position on this yet, nor has issued any clarification. So if the issue is ultimately challenged with the division, there's just no way of knowing how the division would rule on this point.
I'm going to do something I've never done before that I know you're going to be able to answer. I'm looking at a lot of these questions that are coming in. Tell me, why would a community association want to have K. Bender Rimbaum represent them? An easy one. Go ahead, you can brag.
Because I think I think the combined knowledge of the attorneys in this firm is over 100 years. I mean, it's something ridiculous. I think the name partners alone have over 75 years of combined experience, right? Like, this is something that they've been doing, from the beginning of their career. And so I think our knowledge, I think our customer service, commitment to our clients, and certainly we're a resource. I think with all the education that we do. So I think overall, I think we're definitely up there in terms of quality. So I would recommend us.
Yes. And how long has the firm been in business?
Oh gosh, over 30 years. Over 30
Amazing.
Years.
That's amazing.
I think I was perhaps in diapers when the firm started.
I see why you decided to go with K. Bender Rimbaum. Let's go to Brad in St. Pete. And by the way, we're going to be going to a break in a few minutes. But before we go to our break, you've got so many classes coming up that we want to give the dates on. I just want to get this question in. This is from Brad in St. Pete. Is a 3-person board legal?
Well, I mean, the size of the board is going to be dictated by the governing documents, right? So specifically the articles of incorporation and the bylaws. just as a practical tip, I know a lot of directors just use the word bylaws to mean all the governing documents, right? And often just look at the bylaws on corporate governance issues. But, associations do have this other document called the Articles of Incorporation. And when there is a conflict between the articles and the bylaws, the Articles of Incorporation will control the issue. And so when you're looking at corporate governance issues such as, the size of the board, who qualifies as a director, you don't want to just look at the bylaws. You also want to take a look at the articles, and obviously if there's ever been any amendments to the articles, and then take a look at the bylaws just to make sure there are no conflicts. So, typically the Articles of Incorporation will state what the size of the board should be, and typically it's, it'll say something like, the board shall consist of no less than, and then provide a number, or it might have a range, right? And so I would just encourage this caller to look at the Articles of Incorporation and bylaws. But there's nothing in the statute that, for condominiums, the only provision in the statute regarding board size is that unless otherwise provided in the documents, the board has to consist of 5 directors, right? So that means you'll have to look at the documents to see what the size of the board for this community needs to be. So if the documents require a 7-member board, then I suppose the answer to the question is, the whether a 3-member board is legal is probably not, right? So again, just depends on the documents.
Okay. So you've got this big schedule coming up for August. We're going to have you do that schedule, and then we'll go to a break and we'll come back with more questions.
Sure.
Go ahead and give everybody a schedule.
So for the rest of the month, right? So we're July 28th. So tomorrow I'm teaching a class on HOA financial literacy and transparency. So we'll only talk about financial issues with regards to HOAs. Now this will only satisfy the continuing education credit for HOAs, not condominiums. My colleague, Peter Mollengarden, will be teaching a class on elections on July 30th. This will be also a webinar, 11 o'clock. Then Alan from the Orlando office will be doing a webinar on Friday, July 31st, also starting at 11 regarding collections for community associations. My colleague Emily from the Pompano office will be teaching a webinar on August 11, also on HOA record keeping and records access. I will be teaching a webinar. Actually, I'm going to be teaching this class at the Sarasota Chamber of Commerce. So this is one of our live seminars. It's going to be a breakfast and learn type of course, and I'll be teaching a class on HOA meeting notices, member participation, and elections. So again, more focused on HOAs. This will only satisfy the HOA continuing education requirement. And then August 21st, I'll be teaching an HOA board member certification as a webinar starting at 10 o'clock. That's August 21st. That's it.
Boy, you've got a busy month coming up. We're going to go to break. Kirsten, tell people how they can reach your office.
Yeah, our main number for all our office locations is 954-928-0680.
And you've got the greatest website. There's so much information on there. What's your website?
www.kbrlegal.com.
Beautiful. We're going to go to break. When we come back, we have more with attorney Kirsten Hens. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
We are back, and we have an expert guest. We have attorney Kirsten Hens with us from the K. Bender Rembaum Law Firm with offices throughout Florida. We are going through questions that we've received in the last 4 or 5 weeks since Kirsten's been with us, and we're going to go to Cindy in Tampa. HOA considering adding amenities. We were just talking about this, i.e. pickleball courts, playground equipment. Should they increase or change type amount of liability insurance coverage?
So I would definitely recommend the board to consult with their insurance agent. All associations should have an insurance agent to guide them on all insurance needs, right? Like we're attorneys, so we're not experts in insurance. So definitely recommend you consult with an insurance agent. Let them know the plan. You're expanding your amenities, adding new amenities, and then confirm what additional insurance, if any, is recommended, right, to protect against, injury and other types of liabilities. Perhaps you already have the coverage, but perhaps you need additional coverage or additional endorsements. So the agent should be able to advise on that.
Here's another question that we get a lot also. This is Barbara in St. Pete. She wants to know, in a condo association, can a unit owner or a board member run a business from his or her unit?
So I'm going to have to presume that, what they mean by, running a business is, a business that, more of like an office job, right? You can work on the computer, you can make phone calls, right? We're not talking about, storing construction equipment or a construction type business that, it's visible from outside of the property. So that's something that's going to be more specifically, dictated in the governing documents. So typically the declaration is the document that's going to contain the use restrictions, what you can and cannot do. I would encourage the caller to take a look at the declaration to see if there's any restrictions against commercial practices. And I don't mean, leasing a unit, for income. That's not what I mean. But the documents would confirm that.
Here's a question from TikTok. Is it a conflict of interest if a board member is a realtor also?
Well, I mean, in and of itself, it doesn't quite satisfy the definition of what a conflict of interest is under the statute. So I would ask the caller, I don't need like a literal answer, but, just for the caller to think about, is the director offering services to the association, or they're just a realtor?
They just answered about selling condos on our property and being a board of directors.
Well, I mean, in and of itself, it doesn't meet the statutory definitions of what a conflict of interest is.
Okay.
So I'll leave it at that.
When a board of director member goes north and we don't have board meetings, how do we get the okay to pay for irrigation repairs that need to be done?
Well, I mean, board members can still hold meetings virtually, right? That's one of the biggest flexibilities that directors have. So you can meet, you can have meetings and provide virtual options. Directors can even meet via speakerphone, right? So not everybody needs to be in the same location. So that's definitely an option during the summer months or the holidays where everybody's dispersed, so that business can continue to be conducted. Just a note for condominium associations: if you do want to have board meetings virtually, there are certain requirements under the statute that directors have to comply with, which includes you still have to have a physical location for that meeting. So it doesn't mean that all directors have to be physically present at the meeting, but there has to be a physical location where either the property manager is present or there's another director that will be physically present at that location. And that physical location needs to be on the notice of the meeting, right? So the notice is going to contain the date, time, the physical location of the meeting, and then it should also contain the Zoom link as well as the call-in number for that meeting. And then the third thing the statute now requires is that these virtual meetings have to be recorded. So just don't forget, you need to record it, and then you also need to post a copy of the recording on your website if you are subject to the website requirement.
Okay. Here's Ben in Palm Largo. Is there any reason the board could not conduct a non-binding online survey of the owners? Since this would be a survey rather than an official vote, I assume a quorum would not be required.
So, I mean, there's nothing, at least in the law, that prohibits associations from conducting these informal polls or informal surveys on specific issues before the board decides to get a formal vote from the owners, right? It's pretty common. So, for instance, I've seen it where before the board decides to spend money on drafting amendments to a declaration on certain use restrictions, they will poll the community to see, for example, do you want leasing? Do you want to prohibit leasing in the community? Do you want to prohibit pets? Just to get a feel of what the community wants or doesn't want, or if they're looking to do a material alteration, right? Maybe they're looking to paint a building a different color, and oftentimes the board will want to poll the community to see what colors they would prefer. And so it's not uncommon. It's definitely not a formal vote. There's no requirement for the board to have a formal meeting or to establish quorum, right? And you would just use those surveys to determine how what formal vote eventually you'll want to present to the owners. Now, when you do present a formal vote to the owners, then you'll have to have a formal membership meeting notice. You'll need to meet quorum requirements, and you'll need to obtain the voting threshold required under the statute or the documents, depending on the issue.
Okay. Here's somebody. This is from TikTok. They want to know, I'm going to be running for my board. I've asked if I'm allowed to send out emails with my bio, but I haven't gotten an answer back. Is that allowed?
So if a candidate wants to has a bio, right, that they want to share with the community, there are certain timeframes within which the candidate has to provide what is referred to as a candidate information sheet. right? Typically 35 days prior to the election, they would have to provide a copy of that information sheet to the board. And if you timely provide that to the board, then the board is required to enclose that information sheet with the second notice of the annual election. And so I would just, make sure that, you're still within the statutory time frame and can provide that to the board.
Okay. This is from Beth in St. Pete. Our HOA management company was bought and old corporation was dissolved. We still have old contracts with the old name of the company. Should we be concerned?
I mean, I don't know that there's, you should be concerned. I mean, I would definitely have your legal counsel take a look at the contract. Most contracts, most service contracts will have some kind of assignment clause, right? Or a clause that addresses these particular situation where, there's a merger or a company is bought out by another company. So, the contract still remains in effect. But if you are looking to renew this contract with a new company, then might be best to just approach them and try to negotiate a new contract with the name of the new company.
Kirsten, if you don't mind, I'm getting a lot of people who are writing in. Would you mind going over your schedule again of the classes coming up?
Yeah. Let's see. So tomorrow, July 29, I'm teaching a webinar on HOA financial literacy and transparency starting at 11. And you can go on our website, and there's a calendar on our website with all these events, and you can register and get the link for the class. So then let's see, Thursday, July 30th, Peter's teaching a webinar starting at 11, elections for community associations. July 31st, Alan's teaching a webinar on collections starting at 11. August 11, there's a webinar starting at 12 on HOA record keeping and records access. I'm teaching in person at the Sarasota Chamber of Commerce on August 12th, starting at 11. And on August 21st, I am teaching a webinar on HOA board member certification starting at 10.
Great. Thank you for doing that. Let me go to our chat line. I am a director on the condo board, and some of the officers insist that there are legal opinions they rely on, but they refuse to see them.
I'm sorry, repeat that.
I am a director on the condo board, and some of the officers insist that there are legal opinions they rely on, but they refuse to let me see them. I guess he's asking, can they do that?
Well, yeah, I mean, legal opinions from counsel to the association are confidential, right? So they are protected by attorney-client privilege. It doesn't mean that just because you're on the board, everybody has access to all these legal opinions, right? If it's something in connection with your specific function, officer position, then perhaps. But just because you're on the board, you don't have automatic entitlement to all legal opinions. So,
okay. This is another one we get a lot of people wondering about. Terry in Clearwater wants to know, what's the liability of the association president of the condo association gets a key to access everyone's unit without anyone knowing?
Well, I mean that is potentially a problem. Um, so associations having copies of keys is not unusual, right? And if the board has adopted a rule, assuming you have rulemaking authority, or if there's a covenant in the declaration requiring owners to provide a copy of a key to the association, then the association can keep copies, right? Then you need to ensure that those keys are maintained in a safe, I don't know, vault or in a safe space, right? And then when you use the keys to access the unit, right, it's not just anytime, right? It's the statute gives associations access, irrevocable access to units, certainly in case of emergency, right? For example, if there's an active water leak, right? And then certainly for maintenance repair obligations, right? Whether it's to repair common elements or any portion of the unit that the association is responsible for maintaining. So there is authority for associations to access. So, this director certainly should not be having copies of keys unless there's, of course, a covenant requiring copies of keys or there's a rule. And then certainly make sure that they're properly kept.
Hey, it's whenever in doubt, go to the docs. So here's Bill and Brandon. He wants to know, we always get one cannabis question. He says, we have more people complaining about people smoking pot in their own unit, and it's permeating through to the neighbors. Do the neighbors have any recourse?
Well, I mean, neighbors always have recourse, right? I suppose there's always the option to call the police, right? Neighbor can also contact an attorney, right? Have the attorney review the covenants and perhaps send a demand letter to the owner. You just have to keep in mind that while well, and that's the other thing, is smoking permitted under the documents? Not necessarily, marijuana, but is smoking in general allowed, right?
Right.
Or not. And the only way you can prohibit smoking in general is through a covenant, right? An amendment to your declaration. Now, if the documents do prohibit smoking, remember that owners, residents are still entitled to accommodation. So if they have a medical need for smoking marijuana, right, then you're gonna have to, review the accommodation request, and you may need to grant accommodation. So I'm just gonna put it out there. I'm not gonna go into any further detail. And so in this particular case, if this individual that's smoking the marijuana is making an accommodation request, has a medical need, that's something that will need to be considered as well.
Do some of the associations not allow smoking in your own unit? I'm just talking about regular cigarettes now.
Yeah, I mean, there are associations that do amend their documents to specifically prohibit smoking inside units. Yep.
What about on the outside?
Well, if association wants to prohibit smoking on the outside, like in the common elements, like parking lots, catwalks, the pool, they can do that by rule, provided the board has rulemaking authority. So that's not something that needs to be specifically in the declaration.
Gotcha. Okay, Cynthia in Lakeland, I'm sure you've discussed this before, but can you go over some of the rules if you decide to have a Zoom meeting?
Yeah, so for condominiums, the new statutory requirements to conduct a virtual meeting is that, and by virtual, and the statute defines what a video conference is, but essentially you have to be able to see, people on the screen. So it's not just audio. The notice of the meeting that will be held virtually has to have a physical location. So as I mentioned earlier, it doesn't mean that the entire board has to be present at the physical location, but you have to have at least someone, a property manager or another director, conducting the meeting from that physical location. The notice also has to include a call-in number. So the link as well as the calling number for those who don't have the ability to log in through the internet and have to call in. And then you also have to record these videos. And then those recordings have to be maintained as part of the official records.
Here's one of those questions I don't understand. I hope you do. It's from Greg in Tampa. He is a condo. He wants to know if there is no bylaw establishing a timeline when a visitor becomes a resident, triggering an application and approval to live in the condo. What determines a change of status?
Nothing.
That was easy.
Right. So your declaration would either address that or it wouldn't. So if it specifically requires these types of individuals to be subject to the approval process, right? If they've occupied the property for a certain period of time, and beyond that, they need to go through board approval, then the board can require an application. If the documents are silent on these types of occupants, then the association doesn't have the authority to approve or disapprove these individuals. So then the board may need to consider amending the declaration to give board this authority.
I got to tell you, your show, we do close to an hour. We do a 50-minute show with you, Kirsten, and it always goes by so fast. I just looked at the clock and it's like, oh my gosh. So I got to tell you, you do such an incredible job, because I see the letters that people write thanking you and just telling you what a great job you do. Tell people again how they can reach K. Bender Rimbaum.
Sure. The main office number is 954 826-0680. You can also reach me by email. It's khenze@kbrlegal.com.
Okay. And the website's kbrlegal.com?
Yes.
Okay. Kirsten's with us the last Tuesday at 5 o'clock Eastern time every month. Kirsten, again, thank you so much. You always do such a great job.
Thanks, Steve. Thanks, everyone. Bye-bye.
Thank you. And that's attorney Kirsten Hens, K. Bender Rimbaum. Folks, if your association doesn't, whether you're in Tampa or the Orlando area, South Florida, Palm Beach area, if you do not have a firm representing you yet, please give K. Bender Rimbaum a call. They are probably one of the oldest in Florida, one of the largest, and there's a reason why they have so many clients. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.